Assalamualaikum warahmatullahi wabarakatuh and a very good morning. Welcome back to our show Learn Legal Now, and inshallah today we will be discussing on the topic of Bai Inah and Islamic product. For that, we have our three honorable guests with us today, which I am sure that they are very knowledgeable and experienced in this field. Before we proceed, I would like to first introduce our first speaker, which is Shariah advisor, Ms. Rasyada, our financial analyst, Ms. Yasmeen, and also an executive from Public Bank, Ms. Syafiqah. Assalamualaikum, how are you doing?
Alhamdulillah, very well, thank you.
Waalaikumsalam, Najwa. I feel great. Thank you for asking.
Very well, thank you.
Alhamdulillah, glad to hear that. Well, ladies and gentlemen, before we begin, I would like to first describe a little bit of background of Bai Inah before we go into a deeper perspective that will be shared from our speakers. Bai Inah is basically a financing contract that is well known among Malaysian financial institutions. By definition, Bai Inah is when a person sells an asset with a specific price with deferred payment until a particular fixed date, and then he buys back the same asset from the same buyer with a lower price by cash. By this definition itself, we should understand that the asset is by no means is useful to both parties, be it for the purpose of consumption or deriving its usufruct, because the reason that they are involved in this transaction is actually to get financing. That's basically the nature of this contract. Am I correct, Ms. Rasyada?
Yes, that is absolutely right, Mrs. Nazlina. And for everyone's information, Bai Inah is considered as controversial among Shariah scholars. However, the Shariah Advisory Council Malaysia accepts the use of Bai Inah in banking and financial institutions, understand that it is khilafiyah problem and needs to compete with conventional bank, which already have high demand from customers.
I see. By the way, I know that our speakers will share details on the legal framework for the product of Bai Inah. However, I have also surveyed some of the legal requirements of the contract of Bai Inah. The requirements of this contract is specified pursuant to Section 29 Sub 1 under Islamic Financial Services Act 2013, which is also called as ISF. Under this section, the bank may, in accordance with advice or ruling from the Sharia Advisory Council or SAC, to specify standards on Sharia matters to carry out the business activities, as well as to give effect on the ruling or advice that was given from SAC. But I wonder, what are the Sharia requirements of Bai Inah? I would like our Sharia advisor, Ms. Rasyada, to clarify on this.
Before I answer that question, I just want to say thank you for inviting me today. To answer that question, this Sharia requirement is underlined by BNM to ensure that the product of Bai Inah is completely complies with Sharia law. So what are the requirements that banks have to follow? Firstly, each sales contract in Bai Inah arrangement must meet all Sharia compliance standards to ensure the validity of the sales and purchase contract. Secondly, the executions of the two agreements must be done independently and separate from one another. The sale and buy agreement must be completed in the correct order, with the first contract being finished before the second contract or agreement is started. Thirdly, the parties in the Bai Inah are not allowed to make any written or verbal commitment to repurchase or resell the asset, because pre-signing agreements are prohibited under this contract. And lastly, the asset traded in Bai Inah must be Sharia compliant, valuable, measurable, and deliverable, as well as must be owned by the seller. Because as we all know in Islam, you cannot sell something that you don't possess, right? It is prohibited.
Oh, that's magnificent and makes sense. Because I am aware that in Islam, there's a hadith of Prophet Rasulullah SAW where he had prohibited true transactions within one time. So no wonder that it has become one of the Sharia requirement for this product. How about the operational requirement, Ms. Yasmeen?
First of all, I would like to thank the program manager for giving me this opportunity to be here today. Thank you once again, Nazlina, for the question. So to answer that, I would love to look back on what is operational requirement. Well, it is an operation that must be carried out in the background to keep the product or process functioning over a period of time. To have a better understanding, I will give the answers in 3 points. First, the notable requirement is that any amount paid to the seller before entering into the sale contract in the Bai Inah shall not be treated as part of the selling price, including profit. And why? Because it will violate the operational requirement arrangement. As mentioned by Ms. Rasyada just now, the contract must be made separately, right? Same goes to the documentation. Point number 2. Written documentation of both the contract must be prepared and represented by 2 separate sets of documents. The third point, or I would say the last point for me, to offer and accepted ijab qabul of Bai Inah must be accomplished in an orderly manner as well. I think this example might help the audience to understand better. The seller, Ali, sells the Bai Inah asset, the house, to the purchaser, Ahmad, by entering the first sale and purchase contract. Subsequently, Ahmad may mutually agree to enter into another sale and purchase contract. In addition to this point, the purchaser, Ahmad, in the first sale contract has the right to take delivery of the asset. That's all from me. I hope my explanations answer the questions well.
That was actually explained very clearly, but I wonder how many banks actually have this product, and what about the real applications in the Islamic financial institutions? Maybe our executive from Public Bank can clarify on this.
Thank you, Sister Nazlina, for the question. In Malaysia, only CIMB, OCBC, Public Bank, and M-Bank are among the 18 Islamic financial institutions that provide Bai Inah contract, which was approved by SAC of Bank Negara Malaysia to allow Islamic financial institutions to offer Bai Inah agreement. These 4 Islamic financial institutions offer Bai Inah contract for Islamic personal financing product, and only Public Islamic Bank provide Bai Inah contract for Islamic personal and home financing product. Generally, the practice of Bai Inah contract for personal financing in all 4 Islamic financial institutions are the same. For example, when a client requires 5,000 in cash, he or she will apply to a bank, and if the application is granted, the bank will sell its asset to the consumer in 5 years installment for RM 10,000. The consumer then resell the asset to the bank for a cash consideration of RM 5,000 as indicated in the Bai Inah sale and purchase agreement. As a result, the consumer will earn RM 5,000 in a cash and pay the bank for 10,000 in installment over a 5 years period. However, in personal home financing, the consumer will pay the developer at least 10% of the total property price, and it will give beneficial ownership to the house. The consumer then went to the bank for a financing, and the client and the bank will execute a Bai Inah contract where the consumer will sell the acquired home to the bank by signing property and purchase agreement. The bank will then resell the asset to the consumer at a greater price than the consumer sold it. In this agreement, it stated that the value of the house sold by the bank includes the value of the home plus the additional profit rate of the bank. Consumer then will pay the installment to bank, and the bank will pay the balance of 90% of the value of the house to the house developer.
Oh, that's quite complicated, right? Because if you ask my personal opinion, even I would suggest the banks opt for some other Islamic product to be used for personal or home financing. Because when something is very contentious among the scholars especially, it would be better to avoid it. Last but not least, I wish to know from all 3 of you's opinions, like, what is the gap analysis for this?
One of the issues or gap that we can see between the guideline that has been outlined by BNM with the industry practice is regarding the sequence of the implementations of akad. Okay, remember that previously I said that one of the Shariah requirement is that the sale and buy agreement must be completed in the correct order and must be done in proper sequence, right? So basically, the first akad must be accomplished first, followed by the second agreement. However, in reality, in industry practices, usually the bank will normally ask the consumer to sign both agreements at the same time to simplify the process. Therefore, the issue of non-Shariah compliance may arise regarding the sequence of akad in Bai Inah in this case.
As I mentioned in the BNM operational requirements area, documentation needs to be independent of each one. That is, there needs to be 2 separate written documents. However, there is a great deal of confusion about this documentation in the industry in practice. By filing the documents, we can resolve the interconditional in the contract, which is an arranged transaction to validate declaration. But others say the legal papers and customer forms can solve the trouble. There is also a party that thinks they are not required to do anything, they are already compliant with the requirements. This practice points to a gap in the emergence of various views on documentation standards. Though BNM has set up the guideline,
There is gap between Bank Negara Malaysia regulation and application of Bai Inah in Islamic banking, as the implementation of Bai Inah is not exactly in line with the Shariah law. Found that the 4 of Islamic financial institutions that offer Bai Inah included the element of wa'ad. The wa'ad element is included because the bank will sell its valuable asset to be a backup asset in the contract of Bai Inah conducted. And these are not follow the guidelines set by SAC of Bank Negara Malaysia, and among the tightened guideline is that there is no wa'ad element in the contract. Remember that Ms. Rasyada said that the party are not allowed to make any commitment or promise to repurchase or resell the asset. Therefore, issue of non-Shariah compliance arises here.
MashaAllah, that was a crystal clear explanation from all 3 of you. We're getting close to the end of our session together on our today's show. Thank you, Ms. Rasyada, Ms. Yasmeen, also Ms. Syafiqah, for the enlightening and knowledgeable discussion for the topic of legal framework of Bai Inah. We appreciate having this mysterious area clarified. Inshallah, may Allah bless our event today. Whatever that is good comes from Allah, and any shortcoming comes from ourselves. Thank you also for the audience for watching, and may Allah bless you, and I hope that this talk have benefited you. So we meet again on the next episode with a new topic. Wabillahi taufiq wa hidayah. Assalamualaikum warahmatullahi wabarakatuh. Bye-bye.